This program is a paid commercial announcement and in no way represents the views of WPHT or its management.
Lehocky is proud to introduce our newest partner, the world champion Philadelphia Eagles.
Now on Talk Radio 1210, WPHT, WPHT HD, WOGL HD3 Philadelphia. It's Legal Eagles Radio with Sam Pond. From the courtroom to the boardroom to Talk Radio 1210. Get educated on the law from one of the most powerful attorneys in the country. Legal Eagles Radio with Sam Pond, featuring who's who in the Delaware Valley legal community. Welcome to the courtroom, and welcome to Legal Eagles Radio, and your host, Sam Pond.
Sunday night in the Delaware Valley. Good evening, everybody, and welcome in to Legal Eagles Radio as we come to you. Another week goes by in the Delaware Valley. We come to you on a Sunday night right here on Talk Radio 1210 WPHT. Glad to be with you and join you on a Sunday night as we roll into the month of September, and we introduce and bring in Jerry Lehocky, who's sitting in the big chair today, Jerry, for Sam Pond, who is a rare Sunday off, or a rare week off, rather. For Sam, nice to have you in. Welcome, my friend.
Joe, it's good to be here. I'm sorry Sam couldn't be here. He's in Paris celebrating his wife's 60th birthday, and hopefully he's having a great time. But I'm happy to be here and happy to sit in his place today. We've
got a great lineup, and thanks for being here, Jerry. We've got a great show and a great lineup for our listening audience. The mission of this program, as we have said so many times when we created the program, was all about educating the listening audience. Our topic of conversation tonight, I think, applies to every single listener that makes up the entire weekly listening audience on Talk Radio 1210 WPHT. So that big number of people that tune in and listen, the topic of MVA limited tort certainly does apply to the audience, to the entire audience.
Joe, there's no question that motor vehicle accidents are top of mind with anyone in the United States, and more particularly here in Philadelphia, as Philadelphia, clearly one of the most populous cities in the country. A lot of cars are coming in and out of Philadelphia, both from a private standpoint and also in a commercial standpoint. You know, and in this firm, we do workers' compensation. And a substantial portion of our work involves people who drive for a living, whether they be private drivers or commercial drivers. And believe it or not, sooner or later, someone's going to get involved in an accident. And that accident may, as I indicate, involve a workers' compensation component to it, but it may also involve a negligence, or as we call in our world, a third-party component to it. And we're fortunate today to have three esteemed motor vehicle attorneys, if you will. And I'm not disparaging any of them by calling them motor vehicle attorneys, but they are experts in that field, and I'm looking forward to educating the Philadelphia area today with respect to what motor vehicle insurance is all about and how the public can best purchase motor vehicle insurance.
Oh, good stuff, and well said. We do have an esteemed panel of guests that are going to be part of the program. Let's do this. Let me go around the table. I'll get some introductions so our listening audience understands who's in the room, and we'll get kind of an opening remark or an opening statement from each of our guest partners or each of our guest attorneys who are in the room, and then we'll get into the first break and then come back and get into some good dialogue. Adam Malamut from Malamut & Associates joins us. Adam, how are you, sir? Nice to see you.
Thank you, Joe. Nice to see you.
Give
Happy
us the
Sunday.
Yeah, same to you, my friend. Give us an opening thought. What's your when you hear it and you hear the subject? Give me some feedback on it.
So you're challenging me because I'm going before a panel here of some awesome, successful attorneys, and I've got to really be on my A game. But I think the best thing that I can introduce here at the outset is the insurance companies. I think we can all agree are not the good guys, and limited tort and other things that restrict your rights, those are things that are manufactured by the insurance companies to save them more money. It affects your ability to make a recovery for injuries that you may have suffered. And on the flip side, the insurance companies taking your premiums and saving money.
And a Malamut from Malamut and Associates, Patrick Rodden from Rodden and Rodden, came well prepared for the program. Thank you so much for joining us here tonight.
Joe, thank you. And let me thank Jerry for the humble invitation. I'm so flattered, Jerry. And I send my regards to Sam and Mimi celebrating their 60th birthday. I was unaware of that. I've been practicing 33 years, Jerry, and I take no exception to being called a motor vehicle attorney. We have prided ourselves on representing injured victims resulting from motor vehicle crashes. As you know, happens every day. We have some statistics that we'll get into. But motor vehicle accidents, like many others, devastate lives, harm families, and I'm just proud to be an advocate for those people and those clients that I represent.
Marc Simon is with us as well. Patrick, thank you for being here. Marc from Simon and Simon joins us for the full broadcast as well. Marc, a big welcome to you, and thank you so much for being a part of Legal Eagles Radio.
Joe, thank you. And Jerry, it's a pleasure to be on the show. I think Adam said it best. We're surrounded by some terrific lawyers here. I think when it comes to limited tort, for an opening remark to the consumer, I think you have to reach out to an expert when you are in a car accident and you do look at your insurance policy, because Adam said it best. Your insurance company, the defendant's insurance company, they're not on your behalf. Their goal is to take in premiums and not pay out claims. They would not be in business if they took your premiums in and they paid out claims. They're going to fight you. Your carrier is going to fight you. The defendant's carrier is going to fight you. If you were hurt and you had an orthopedic injury, you wouldn't diagnose your own injury. If your car broke down, you wouldn't go and fix your car yourself. So when you have a legal claim or a legal issue, and you need to know your rights, and you need to understand the difference between what limited tort and full tort is, you need to go and talk to an expert, just like you would if you had a physical injury, a mental injury, or something that you own broke down.
Joe, let me jump in if I can, because I feel like it's necessary that even with this small radio show tonight that we start to change the narrative, because all of us have been victims of the insurance industry marketing juggernaut. And we all refer to limited tort as limited tort. It's the wrong message. It's limited rights. That's what it is. When you purchase a limited right policy, you are buying less than what you are entitled to. And you are basically agreeing to limit your ability to be compensated by someone who has negligently injured you in a car accident. And if the three or four of us start today with changing that narrative, I think it will make a difference in terms of juries who hear this and the general public. It's the wrong message. It's limited right, not limited tort.
I challenge the listening audience, and Patrick, I'll let you weigh in on this. Do you know what decision you've made when you made that purchase? Is that where the mistake first begins?
It is, Joe. We see time and time again with our clients who come to us after a motor vehicle accident. We ask them to bring in their declaration page, if available. If not, we will ask the agent or carrier to send it to us. But I can tell you countless times, Joe, I reviewed those declaration pages with very sophisticated clients, and they're looking at it for the first time, more or less, particularly with the advent of the Internet, where many people are clicking and clicking, simply trying to save a premium dollar. So when we go over the coverages, we explain first liability, under and uninsured motorist coverage, and then ultimately the tort selection, which is important. Now, when they select limited tort, they're unaware that the insurance company is now going to make the determination of whether their injury meets their protocol standards. And I can tell you in my 30 years of practice, Joe, there's very few injuries that meet that protocol unless they're clear and convincing and obvious. A surgical case, in fact, fractures have even been challenged by the carriers as being a serious injury to get over the threshold. So the full protection that we recommend to our clients, if it's affordable, that's what I think we need to get into during the program, is it's a budget decision on when you buy insurance like you buy any type of insurance. And unfortunately, the way the pricing structure was dictated by the insurance company in Philadelphia, you can have a full tort policy cost nearly 30 or 40% higher. Am I correct, Marc, in that estimation?
Absolutely.
Yeah, and that discourages most consumers in buying automobile coverage. Now, if I may hold the topic on that, What I counsel my clients on is, if you can't afford buying a full tort policy, which I encourage everyone to do, purchase as much insurance as you can on your under and uninsured motorist coverages. And what those coverages do is protect you in the event that you're struck by an uninsured motorist or a phantom vehicle, and then you can pursue the claim against your own insurance company. If you're seriously injured, it's unlikely that the limited tort is going to bind you to meeting that threshold. So my advice to the listening audience is purchase as much uninsured and underinsured motorist coverage you can afford.
About a minute and a half till we get to the to our opening break. Marc, once the decision is made on the purchase, at that point there's no way to change if an incident occurs.
Well,
you live with that decision.
To follow up on Pat's point, look, unfortunately, most of the listening audience, most of all Americans are living paycheck to paycheck. And the things that we all generally take a hard look at are, first, our health insurance premiums and the limitations we get when we do get sick. We look at things like our cable bill, our cell phone bill, and right up there is the car insurance. And about half of the Pennsylvanians that drive do elect limited tort. Some know, some don't know. Nothing to be ashamed about. The insurance companies will tell you that limited tort means you cannot sue for anything. And as Jerry said, we need to change the dialogue today. Limited tort means limited rights. It means if you are injured and your injuries are significant, that you then have the same rights as somebody who elected full tort. It is never too late to change your coverage. You should always evaluate it every year. In today's market, where there are 50 carriers all online who can give you quotes within minutes, we've all seen the commercials, you should always reevaluate where you are personally in your financial situation and where the insurance company's premiums are for limited and full tort.
This is Legal Eagles Radio with Sam Pond, from the courtroom to the boardroom to right here on Talk Radio 1210 WPHT. We'll take our first break and come back in a minute.
If you want to talk with Sam Pond or any one of his legal experts, call 800-568-7500. That's 800-568-7500.
Legal Eagles Radio with Sam Pond on Talk Radio 1210 WPHT. Jerry Lehocky in the big chair tonight as we come to you around the Delaware Valley, and we thank our growing listening audience who continues to tune in every Sunday night. Our topic of discussion, Jerry, MBA, limited tort, a good one from the opening remarks from all three attorneys who are joining us tonight. Adam Malamut from Malamut and Associates, Patrick Rodden from Rodden and Rodden is with us. Marc Simon is with us from Simon and Simon, and also in the room, one of the rising stars from Rodden and Rodden, Matthew Breslin, is with us. He's observing as well. J-Doc is here somewhere. He may have gotten offended because I booted him off the microphone, but that's okay. We'll try and work him in to the show as well.
Joe, I wanted to follow up with something that Mr. Rodden mentioned during the first segment, and that is the purchase of UM and UIM coverage, uninsured motorist coverage and underinsured motorist coverage versus purchasing full tort coverage. And Pat, can you explain those differences in costs?
Yeah, absolutely, Jerry. And it's a valid point for your listeners. In fact, I have a sample declaration page that I brought with me from one of my current clients. I don't profess to be an insurance agent in terms of the rating system, but I have seen enough insurance policies to know that the big capture cost for the insurance company is liability coverage, which means if you cause the accident, they'll indemnify you up to the amount that you purchase, okay? That's the highest level of rating that they afford to the policy. When you get down to the uninsured and underinsured motors, it's de minimis. I'm looking at a policy where they're charging $6 for $100,000 worth of under and uninsured motorists. That's how de minimis the coverage is. Now, many times agents do not offer that. They will put a basic policy in front of a customer who comes in and says they want to be cost conscious about what their spending is on the insurance policy. So again, what we talked about in the previous session is if a household cannot afford the full tort, which could be 30 or 40% higher overall premium, we strongly encourage them to buy as much UM and UIM coverage as they can afford.
Adam?
By the end of the show, I'm sure the listeners will understand my disdain for insurance companies. I have no problem with people making a fair wage for what they sell, but here the insurance companies create this limited tort, limited right to sue, which only benefits them. The mechanism, the ability to buy your insurance comes through one of two different ways. You either fill out a coverage selection form, a paper form, or you go online and go through series and series of menus and click downs and, hey, you can save more money if you click this button. And to Patrick's point and to what Marc was speaking of earlier, it really comes down to very burdensome choices that the consumer doesn't necessarily understand, and that's by design. The insurance companies don't want people to understand that. So the more you understand, the more informed consumer, and that's going to take away their ability to direct how they want you to buy your insurance policy. So as you fill out your coverage selection form, think of it as going to the supermarket and going and picking up some dairy product or eggs. You're going to look for an expiration date. You're going to want to know a little bit more about it. And if you see it's close to the expiration date, you may ask one of the people in the meat department, hey, I see that it's got a sell-by date here. How long is it good in the refrigerator afterwards? You're going to gather information. People aren't in the habit of doing that about their insurance policies. And it's really important that you, if you take away one message from me tonight, it's take the opportunity to educate yourself. Take the opportunity to pick up the phone, call an insurance broker, call a lawyer, preferably a lawyer, but call somebody who can educate you outside of just following the prompts that the insurance companies put out there to direct where they want you to purchase their products.
I almost wonder, and Marc, Simon, I don't know how you feel about this, but I almost wonder if we should not purchase our insurance online anymore.
Yeah, we buy everything online today.
We do, for convenience.
Amazon bought Whole Foods, and I couldn't tell you the last time my sister purchased anything in a physical store. I think the reality is that it comes down to what it's come down to for the last thousands of years. Price sells. Price sells cars. Price sells items. We live in a very price-conscious world. Unfortunately, whatever the insurance companies do or do not do, most of the listeners are going to elect limited tort, even after the great points by Patrick and Adam that you must educate yourself. Unfortunately, it's going to come down to your budget, and you have to send your kids to the best schools, put food on the table, you have to put gas in your car. Unfortunately, the reality of the world is that the difference in price between limited tort and full tort, at least in the urban parts of Pennsylvania, Philadelphia, Pittsburgh, some of the surrounding counties, is so egregiously different, almost double to purchase full tort insurance versus limited tort insurance, that most of the people, even if they're educated, even if they do their homework, even if they call their lawyer, are going to make a decision based on their own finances to elect limited tort.
Yeah, I just want to pick up on that. Thank you, Marc. What I tell my clients, I analogize it to, you wouldn't buy $15,000 worth of life insurance, would you, in hope that that would protect and provide for your family in the event of a death? Comparing that to an auto policy, and we see many, we even touched on the mandatory minimum state requirement, which is only $1,530, and it's been in effect for over 30 years. And Jerry's well aware of our organization trying to change that, and we just haven't been able to get any headway with that. But perhaps that's a topic for another time. It is. But again, I don't want to disparage all insurance agents, but I've dealt with enough of them that I feel they don't properly inform the consumer of automobile insurance, and then it lands in our lap to explain to them why they have insufficient coverage.
Just to go back to Marc's point for a minute, I don't want the listening audience to take the message away that if you have limited tort and you get involved in a car accident, you shouldn't call a lawyer because you have no cause of action. I think it's very important and I'll, quite frankly, I know Marc has had huge success on behalf of his clients, and Patrick has, and Jerry has, and we've had huge success on behalf of our clients in limited tort cases. it's just not preferred, and you just need to know what you're getting involved with. There's still opportunities to do things to protect your benefits. It just puts up roadblocks. So I want the listeners to understand that in the event you do get into an accident, and I hope that you don't, still pick up the phone and call a lawyer because there still may be a viable cause of action.
And the only way you're going to understand whether or not you have a viable cause of action is to talk to an attorney who specializes in that area. Am I right?
That's right.
And one thing that we don't want to miss to the consumers and the listening audience is that we do not charge a fee unless we are successful in recovering money for you. All of us in this room. I could never imagine being in a situation again in my life where I would charge a fee for somebody to talk to me. So when you pick up that phone to call a lawyer, remember, you can call any of us 24 hours a day, 7 days a week for free. If you want us to read your mail, if you want us to read your policy with you, if you want us to look at pictures of the accident, if you're not sure what hospital to go to when you've been injured, pick up the phone and give us a call.
Legal Eagles Radio with Sam Pond here on Talk Radio 1210 WPHT. Thanks for the segue, Mark. The Legal Eagles listener hotline is open, 1-800-723-8715. 1-800-723-8715. We'll continue the dialogue and the conversation. We'll bring J-Doc into the conversation as well when we come back on Talk Radio 1210 WPHT.
Now back to Legal Eagles Radio with Sam Pond. Talk Radio 1210 WPHT.
Sunday night in the Delaware Valley here on Legal Eagles Radio with Sam Pond. Jerry Lehocky sitting in for Sam Pond on this Sunday evening. Patrick Rodden from Rodden and Rodden is with us. Marc Simon from Simon and Simon. Adam Malamut from Malamut and Associates joining us as we come to you on a Sunday night with our topic of conversation, MVA and limited tort. Jerry?
So we talked about the purchase of insurance. Let's move it forward to the actual occurrence of a motor vehicle accident and a client coming into one of your offices with a specific type of accident. And clearly, we all know what a rear ender is. Someone who gets hit from behind by someone else. But there's other types of accidents that may or may not come under the limited right umbrella. Adam, give us an example of an exception to that.
So in New Jersey, it's interesting. The exception historically was the commercial exception. So in 1995, and without boring the audience with the history of the law, the Auto Insurance Cost Reduction Act, ACRA is the acronym, was enacted. And that changed the way people looked at insurance for limited tort versus no tort versus zero threshold, where you had unlimited right to sue. An exception to that was if you were hit by a vehicle or a passenger in a vehicle that didn't carry PIP. And without going too far, PIP is personal injury protection insurance. New Jersey is a no-fault state. The insurance companies have gotten hip to the fact that they were giving away this opportunity to sue, and they've started putting PIP or selling PIP to commercial vehicles, which in limited doses we've seen where we might have thought that there would be no threshold, that limited right to sue. So in New Jersey, really the biggest distinction, or the biggest exception rather, is that commercial policy exception where there's no personal injury protection.
Patrick, how about another exception?
Yeah, I'll speak to the Pennsylvania exceptions, Eric. Touch on two, and then I'll pass on to Mark. One that we see often in our practice is intoxication, drunk driving, and that really incites a jury and gets the attention of insurance companies. If someone selects limited tort, but they're involved in an accident with a drunk driver, that exception allows them to revert to full tort. So there's no issue as to that. The second one is an out-of-state vehicle. We do not give the benefit to an out-of-state resident who causes a harm in an accident in the Commonwealth of Pennsylvania, and the person who selects a limited tort involved in an accident with an out-of-state defendant would revert to full tort. Mark?
Yeah, so I call it an exception, but really the number one exception, remember, when you elect full tort versus limited tort, the only difference is that for your pain and suffering, for your loss of life's pleasures, you cannot get money from a jury, a defendant, an insurance company if you select limited tort until you prove that your injuries rise to the level of a serious impairment of a body function. That's what the law says, serious impairment of a body function. So if you're in a full tort, if you elect full tort, or you are deemed to have full tort, based on those exceptions that my colleagues have shared with you, that means you can recover pain and suffering, loss of life's pleasures, embarrassment, all of the damages that you've suffered for not being able to do the things you could do before the accident or incident, for anything. You stub your toe and you can't walk up the stairs for 3 days. You can recover money if you've elected full tort. Whereas if you elect limited tort, you must prove that those injuries are more severe, more involved. They affect your life in a more substantial way. To rise to the level of a serious impairment, if you can prove that serious impairment along with your counsel or your lawyer's help, then limited tort and full tort become the same thing.
Gentlemen, how does auto insurance affect the passengers in a car as well as pedestrians?
Good question, Joe. Well, automobile insurance coverage follows the individual. In fact, I had this very issue come up before I came to the segment today. I have a client who I'm going to be meeting with tomorrow, was in a lift vehicle after taking her car for service, and the lift vehicle was in a high-speed accident right down here on Essington Avenue. So in interviewing my client, I had to ask her what her car insurance was, and she was taken back by that. She says, "What do you mean, Mr. Rodden? Why do I got to tell you who my insurance company is? I was in a lift car, and the lift car got broadsided." And needless to say, Joe, it's very difficult to explain that it's the law. Many of my clients put their full trust in us, but you got to walk them through it. So if someone's in a passenger in a vehicle, they have their own motor vehicle insurance, it follows them. If they don't own a motor vehicle, then they get the coverage that's applicable to the host vehicle.
Now, Mark, you mentioned the loss of life's pleasures. I'm familiar with a case where somebody played the piano, and literally speaking, they couldn't play piano anymore. They were in a car accident. And are you talking about issues that can be specific to individuals who may have specific life's pleasures?
Absolutely. Loss of life's pleasures is different for a 10-year-old kid who isn't able to go to gym for 6 weeks, or your 80-year-old mother who already struggles with some limitations in her life, and now she has even further limitations. So it doesn't mean you have to go from a 10 to a 4 in terms of your activity. You could go from a 2 to a 1 and have a significant amount of a loss of life's pleasures.
Adam, is there any difference between being the passenger in the lift vehicle or being a pedestrian and struck by a lift vehicle?
That's a good question. The ability to get the medical coverage, at least from New Jersey, is going to be a lot easier if you're the passenger in the lift vehicle, assuming that you don't have your own vehicle, assuming that you don't have private health insurance. Certainly we hope nobody's getting struck as a passenger, or as a pedestrian. That usually doesn't bode too well. But it's really fact sensitive for each individual incident, depending on that person's individual situation.
So if I'm a pedestrian and I don't own a car and I don't have health insurance, my only source of protection is hopefully the Lyft driver's automobile policy, assuming they had a valid policy.
That's correct.
I'm sorry. When somebody gets in a car accident in PA, a lot of times, and in Philly specifically, you call the police. A lot of times they don't come. What do you do in that situation where you call the police? It's not an absolute tragic auto accident, but still serious. What should an individual do who's totally in a panic at that point in time? What are the steps they should take?
Just let me clarify, Joe. So you're saying they place a 911 call and no response?
Right.
Of course, you try to get the driver's information involved in the accident, and what we would instruct our client to do is immediately go to the district where the accident occurred, and at that point they will take a report. The Philadelphia police, who do tremendous work,
sure, they have
set up standards, correct, Matt, that unless it's a reportable accident, they don't want to be using the resources. And I understand that. I don't always agree with it, because there's a very important point I'd like to make, Joe. When you pursue an uninsured motorist claim, one of the requirements to do so is it has to be reported to the police, and that's to vet out any type of fraudulent situation that may occur. So in that instance, it could prevent a injured party from actually pursuing a claim if the incident is not reported to the police.
If I can, I want to go back to Jerry's question because he raised an issue that is a very hot issue today with the influx of Uber and Lyft and other ride shares. There's a lot of litigation, and our firm has a lot of litigation that involves not just the driver and their personal policy, but where we're going after the ride share companies for potentially not screening their drivers well enough. Perhaps truck drivers, for example, are only allowed to work so many hours. Well, rideshare doesn't have those rules. So perhaps a rideshare driver, like a Lyft driver, may be on the road for 12 hours, which might be patently unreasonable, especially if you're sitting in traffic, driving in Center City or the Schuylkill or some very congested area where it's even more exhausting being on the road that long. So to answer your question, Jerry, which I think is a great point for our listeners, there may be a number of different causes of action. Some of the impediments to those causes of action are whether the Lyft driver was actually operating as a Lyft driver at the time. If the Lyft driver was not acting as a Lyft driver, which is always something that we'll find out during litigation, during discovery, it may just be a matter of going after their personal policy. But if they were operating as a Lyft driver, we've got some very interesting cases, one involving intoxication by a rideshare driver that had some drinks and then clicked the app and went and caused a very significant accident. So in that particular case, we have a bar, we have a rideshare driver, and we have the rideshare company.
And your hope is then to find the most coverage you possibly can to protect your client.
Oh, 100%, because the insurance companies, as we all know, aren't going to voluntarily pay anybody.
We know that.
This is Legal Eagles Radio with Sam Pond as we come to you on Talk Radio 1210, WPHT. Fascinating conversation for all of the listening audience tonight, me included, as we try and navigate our way on a daily basis around the Delaware Valley. We'll continue with our final segment here on Talk Radio 1210, WPHT. Jerry Lehocky in for Sam Pond tonight. Back in a moment.
Oh, yay, oh, yay, oh, yay. God save the United States and this honorable court.
Talk Radio 1210, WPHT, Legal Eagles Radio with Sam Pond.
Back here on Talk Radio 1210, WPHT. Along with Jerry Lehocky, I'm Joe Kraus. Great panel of guests tonight. Adam Malamut from Malamut & Associates, Marc Simon from Simon & Simon, Patrick Rodden from Rodden & Rodden, and J-Doc, of course, joining us. And sneaking in for the final segment, that rising star that I mentioned earlier, Matthew Breslin, is going to be part of our final segment. Jerry, I toss it to you. Our closing segment. Good information for the listening audience today.
So let's take this as it naturally progresses through the occurrence of a motor vehicle accident. So we bought insurance, we're involved in an accident. Now we need medical care. Gentlemen, what do you say to your clients about getting medical care? And can you talk about the difference between primary coverage and secondary coverage? And what kind of limits are there to get medical coverage under an automobile insurance policy?
Sure. So if someone is involved in a motor vehicle accident, obviously if they're injured, our first suggestion would be to obtain some type of emergency care, be it through an emergency room at one of our hospitals or an urgent care center, so that there is an immediate report of those injuries. In Pennsylvania, under our auto insurance policies, typically we have $5,000 in PIP coverage, personal injury protection. That coverage will apply to not only that ER visit, but any follow-up visit that someone may need to treat for their injuries. Now, it's important to note that when someone goes to an emergency room to report an injury, many times those emergency rooms are not equipped to fully diagnose the conditions that may have been caused by the accident. That's why we suggest that our clients, when they come to us, go to a facility, be it a pain management facility or a chiropractic facility or a physical therapy facility, so that they can be properly evaluated, diagnosed, and treated for those injuries.
Gentlemen, we know in this world today, $5,000 worth of medical coverage doesn't get you much, if anything. What do I do if I only have $5,000 in coverage and I don't have health insurance?
Good question, Jerry. And the answer is, if there's no health insurance beyond the $5,000, you're out of pocket, and we're negotiating with whatever medical provider you owe money to. Now, you can board those excess medicals and try to recover them against the tortfeasor or the motorist that caused the accident. But again, that's all determinative of how much liability coverage is on the other side.
Pat, I'm sure our listening audience doesn't know what boarding means.
Boarding means that you provide them to the insurance company for the motorist who caused the accident, and you include them along with all other items of damage.
Them being the bills.
That is correct.
All right.
That is correct.
So if I could just take that a step further, in New Jersey, we're not allowed to go into court and ask for a specific amount of money. Patrick used the term boarding. It's a term that we use in the legal community, but basically what that means is putting on board, putting in front of the jury economic damages. So we can't go in and say, my client was injured, and for his or her pain and suffering, you should give them $1 million. But what we can do is go in and say, if you find that my client was injured and it was a result of the defendant, then my client's entitled to pain, suffering, and we like to put as many lines on that jury verdict sheet as possible. The more lines, the more money the client gets. Pain, suffering, and then past medicals, present, future medicals. So when we talk about boarding, that allows a jury to really understand what our client has gone through from a medical perspective, from an economic perspective, because every accident, whether it's a work-related accident or an auto accident, changes people's lives. In some fashion, it's going to change your life. No matter how minor, that's going to be some defining point in your life. It's important for us to be able to get all of that information to the jury. So to answer your question, Jerry, in New Jersey, what we would do is we would ask a jury to consider all of the reasonable and necessary medical treatment that our client received. We would have somebody testify to that it was reasonable, it was necessary, and the cost of that treatment was whatever the cost was. Beyond that, we also ask for what future medical treatment is. And that allows us to put a number in front of a jury that not only compensates our client, but makes sure that our client is made as whole as they can be.
Patrick, let's talk about the situation where someone is involved in a motor vehicle accident. They have primary coverage in an automobile policy, and they also have health insurance where the costs of the medical far exceed $5,000. What happens in that situation?
Jerry, the secondary health insurance would then be primary. So any treatment that is needed after the exhaustion of the $5,000 would then be submitted to the client's personal health insurance. So
the client says to you, Mr. Rodden, you mean I have to pay co-pays now to get treated for a motor vehicle accident that wasn't my fault? Why is that?
That is correct, Jerry. Yeah.
And do I get those co-pays back?
You do. Again, that's part of the itemization of damages that you submit to the insurance company on behalf of the wrongful driver.
And what happens to the money that the health insurance company had to pay for this accident that was somebody else's fault?
Well, that's an interesting question. Sometimes they can assert a subrogation right, which means that they now asked us as the attorney of record to recoup their expenses. However, that is a technical demand in the sense that it has to come under an ERISA program. And if it's a non-ERISA program, then there is no right of recovery by the health carrier.
Does that claim on my health insurance affect me in my next year's premium?
Go ahead, I'm sorry.
That's okay. That's a great question. We would love to have the holy grail as to how the insurance companies put together their premium formulations. So we like to tell people that it doesn't, but we can't guarantee that.
So I may be at risk of having to pay a higher health insurance premium in the year following a motor vehicle accident that I was involved in that wasn't my fault.
In theory, yes, you may. However, you also you can't ignore what your body needs, and if you need the medical treatment, you need to get it. You need to get the medical treatment.
Jerry, last word.
Well, listen, I want to thank our esteemed colleagues for spending the time tonight talking about motor vehicle accidents, talking about limited right insurance and the different aspects of that limited right insurance. I'm sure that someone out there has a question, and I urge them to contact one of our esteemed colleagues tonight and raise the question, whatever it may be, as it relates to a motor vehicle accident, because I'm certain they're going to get excellent representation.
Special thanks to you, Jerry, for sitting in for Sam Pond this evening. Special thanks to Adam Malamut from Malamut and Associates, Patrick Rodden from Rodden and Rodden, Matthew Breslin, who made his debut in the final segment. Well done, Matthew, and Marc Simon as well. Great job from Marc Simon from Simon & Simon. Of course, J-Doc, I'll never forget about your contribution to the show on a weekly basis. You know I appreciate it very, very much. I thank our listening audience for being a part of Legal Eagles Radio with Sam Pond, from the courtroom to the boardroom to right here on Talk Radio 1210 WPHT. Remember the Legal Eagles listener hotline, 1-800-723-8715, 1-800-723-8715. On behalf of Mark, Patrick, Adam, Matthew, Jerry, and our gracious host Sam Pond, along with J-Doc, I'm Joe Krause. See you next time, everybody.
So long, Joe.
This program is a paid commercial announcement and in no way represents the views of WPHT or its management.